Ready? Start. In the judgment of the case, G.S. Raisoni College of Engineering, through its director, Dr. Sachin Untawale versus Manisha Manohar Ingre, RTMNU, and Joint Director of Technical Education, Nagpur, pronounced on May 9th, 2025, Justice Mukulika S. Javadkar has at the Nagpur bench of the Bombay High Court, while allowing the writ petition, confirmed the order of termination of services of the respondent, Assistant Professor, Electronics and Telecommunication, Manisha Manohar Ingre, by quashing and setting aside the impugned order passed by the University of College Tribunal, Nagpur, on May 6th, 2024. Para. The respondent 1, Manisha Ingre, had applied for the post of Assistant Professor in Electronics and Telecommunication in the Petitioner College and was appointed on June 1st, 2015. She was on probation for a period of 2 years from June 1st, 2015 on June 10, 2015. Immediately after her appointment, the respondent 1 moved an application with the director of the Petitioner Institute seeking maternity leave. Para. The petitioner institution granted 6 months maternity leave from June 10, 2015 to December 9th, 2015. Thereafter, she also sought extension of the said leave for another 4 months, that is up to March 31st, 2016. The petitioner had extended the leave and also started the probation period afresh from April 1st, 2016. She was irregular throughout in discharging her duties. She did not report as and when required. She also even did not show any inclination to register for PhD, which is a prerequisite for her post to be permanent. The petitioner issued a letter on February 20, 2018 and extended probation period by 1 more year till March 31st, 2019. Para. The respondent 1 failed to discharge her duties as expected despite of all the reminders. The petitioner terminated her service on unsatisfactory grounds and an amount of rupees 51,792 was deposited in her bank account in lieu of 1 month's notice. Para. Being aggrieved, Ingre filed an appeal passed by the petitioner institution before the University and College Tribunal, Nagpur, along with application for continuation of delay for filing an appeal. The tribunal condoned the delay and on May 6th, 2024, the tribunal passed the judgment and order and granted reinstatement to the respondent Ingre with 75% back wages. Hence, this termination order was challenged by filing this petition. Para. Clause 446.1 of UGC regulations specifies that to be appointed as an assistant professor in colleges with engineering and technology discipline, essential is first class master's degree in the appropriate branch of engineering and technology. The petitioner has not claimed anywhere that she did not post graduation in first class and in the appropriate branch of engineering and technology discipline. Moreover, if termination order is perused, it was simply on unsatisfactory performance. Para. Even if it is held that PhD is not required, still it is not satisfactorily established by the respondent Ingre as to how she is qualified to be appointed as an assistant professor in view of clause 4.4.6.1. It was contended on behalf of the respondent that the judgment of the case YKV Jairaj and others versus Kalyani Mathivanam 2015 6 SCC 363 would not be made applicable in the present set of facts as in the said matter the state of Tamil Nadu has not adopted the UGC guidelines. However, in Maharashtra also there is no amendment to the Maharashtra Public Universities Act and the notifications and regulations would govern the services of the professors and other designation. Admittedly, the petitioner college is autonomous and not receiving any grant from the UGC para. The High Court's attention was drawn to the UGC Guidelines 7.4.0, which reads 7.4.0. The universities, state governments shall modify or amend the relevant act statutes of the universities within 6 months in adoption of these regulations para. Though this has been the direction, however, there is no such modification by the state of Maharashtra in the Maharashtra Public Universities Act or any modification by the university. In fact, it is not necessary to assign any reason while terminating services of probationer para. As the respondent availed maternity leave of 10 months immediately after her appointment, there could not be any assessment of her performance and therefore fresh order issued in respect of probation commencing from April 1st, 2016. Her probation was extended by another 1 year, which was duly accepted by the respondent Ingre. Letter of February 20, 2028, whereby period of probation is extended, is very specific that she has called for gathering work, but she has not reported. She has not registered for PhD. Negligence has been reported in handling work at many places para. She was informed to execute responsibility and task assigned to improve performance and deliver. There is no challenge to this letter and she accepted her extension of probation. She has also signed clearance form. The appeal has been filed after 1 year without showing insufficient cause. The delay was condoned para. The joint director did not file reply whether the state government has adopted UGC regulations and statutes by way of amendment. As such, after going through the documents placed on record and citations relied upon, the High Court has voiced satisfaction that due procedure has been followed by the management before terminating the services of the respondent probationer. Her performance was not satisfactory as per the petitioner. No bias is seen. On perusing the documents, the court found that she was immediately given maternity leave after joining duties for 10 months. As her performance could not be assessed, the fresh order of probation in her favor for 2 years was duly accepted by her, and she even thanked the management for that para. In the opinion of the High Court, if there was any bias or personal grudge against the respondent Ingre, management would not have granted opportunities to her to improve her performance. As such, there is no illegality in the termination of service order passed by the management para. The college tribunal has also not discussed as to whether appellant respondent 1 is entitled for 75% back wages. According to the High Court, the respondent number 1 is not entitled for any back wages.